that you are a danger to our society, I am going to set bonds. I'm going to set bonds in each of your cases at $300,000.
Before this hearing even begins, here's what makes this case so unusual. The defendant had only recently been placed on deferred probation, a second chance that allowed him to avoid a conviction as long as he followed strict court-ordered conditions. But according to prosecutors, that opportunity unraveled almost immediately. Instead of showing progress, they allege that within just a couple of months he picked up multiple new criminal charges, including aggravated robbery, assault on a peace officer, evading arrest, resisting arrest, repeated failed drug tests, missed drug screenings, and violations of probation requirements. That combination immediately changes the tone of a bond hearing. This isn't simply about deciding whether someone should be released while awaiting trial. The judge also has to determine whether the defendant presents a danger to the community, whether he is likely to comply with court orders, and whether any amount of bond could reasonably protect public safety. Pay close attention to how both sides frame their arguments. The defense isn't arguing innocence here, they're focusing on the defendant's legal right to request bond and asking the court to set a reasonable amount. Meanwhile, the prosecution is building a picture of repeated violations and escalating behavior to convince the judge that release would be too risky. One detail you'll notice throughout this hearing is how carefully the judge asks questions instead of rushing to a decision. Every question about the defendant's criminal history, probation status, finances, and living situation serves a legal purpose. Those answers will directly influence whether bond is denied, granted, or set at a very high amount with strict conditions. As you watch, ask yourself this: if someone receives a second chance through probation and is accused of committing similar crimes almost immediately after.
Ensure, please.
Did she print out the orders on those? Is that this?
Yes, ma'am.
Okay. So clause number is 25 DCCR 1382, which is an assault on a peace officer, and 25 DCCR 1385, which is a robbery, are both motion to revoke probations. And there are no bonds currently set. Is that correct in those cases? And Mr. Kimler has filed a request that I set a bond in each of those cases. It's like there's been a first amended filed in each of these. So he was placed on probation February 3rd of 2026. In both cases is 10-year deferred probations. And the allegations are a new aggravated robbery from April of 2026, testing positive for cocaine on several occasions, failing to submit to drug or alcohol screening on several occasions, failed to comply with Texas Drug Education Program, a new offense of evading arrest or detention from February 6th, resisting arrest or transportation February 6th. And so, Mr. Kimler, you may proceed.
Well, Your Honor, they're deferred adjudicated probations. We would just request arrangement for TRP bonds. If the bonds are denied, we would request a disposition on the MTRPs within 20 days and request for the bond pursuant to the Code of Criminal Procedure.
Is there any evidence with regard to your client's ability to make a bond, or?
Well, Your Honor, I think he's entitled to a bond. I haven't filed a writ to challenge the amount of the bond because it hasn't been set yet. So I'll wait for the court to set the bond. If that's excessive, then I would follow.
If I'm going to set a bond, I need to have information on what his ability is so that I don't set one and then we're back in here.
At this point, the hearing shifts into something many viewers overlook but that can have a major impact on the outcome. The judge is no longer discussing only the allegations, she's gathering financial information to determine whether any bond she sets is realistic. Courts generally don't choose a number at random. A defendant's income, assets, employment, living arrangements, and overall ability to pay can all become relevant when setting bond. Notice that the judge specifically asks about income, disability, assets, transportation, and housing. Those questions aren't meant to determine guilt or innocence. Instead, they're part of evaluating whether a bond amount would reasonably ensure the defendant returns to court without becoming effectively impossible to meet. At the same time, financial hardship doesn't automatically outweigh public safety concerns. If the court believes someone presents a serious risk to the community, that concern can justify a substantially higher bond despite limited financial resources. Based on everything you've heard so far, do you think the defendant's financial situation should carry significant weight, or do the new allegations overshadow those factors?
With the jail?
Yeah, they just put me on the new medicine, and it's been working good with everybody on the dorm say I haven't been having seizures or outbursts.
What medication are you on?
I've been trying to get the name of it, but I try to ask my nurse the name of it this morning, but I was sleeping.
Are you functioning okay now?
Yeah, I'm functioning way better than now. I haven't, but when I got here, when they first booked me in, I had like they definitely in the booking was on the booking in the front booking for like 4 days, and I had like 5 seats there.
If the judge grants you a bond and you're able to get out, would you follow up maybe as a condition of your probation or condition of your bond with MHMR
Yes, sir.
to continue the treatment?
Yes, sir.
And as far as your other financial assets, you don't own your own car, do you rent, or where do you live?
I stay with my mom.
And your monthly expenses about what are these? As far as food?
She pays the bill, and I'm on food sale.
Password.
No questions, Judge.
It's for the record, I'm taking judicial notice of the court's files in all of the cases. And so give me just a second. I'm right now going over the probable cause affidavits and those 2 new offenses. Then I'm going to get to something else as well. Any witnesses, Mr. Smith, or just argument?
Just argument.
All right, give me just a second then.
Oh, my dude. Judge, I understand that these are deferred cases, but the state is opposed to setting bond based on the nature of the crimes that he was on probation for and the nature of the crimes that he committed within 2 months of being placed on probation for these first robberies. He, on top of the 2 felonies that are filed, there's also evading and resisting that are pending in misdemeanor court. He has failed several drug tests. He's refused to take other drug tests, indicating to me that he is probably under the influence of illegal narcotics most of the time. And for those reasons, I believe he is a danger to our community, and I would request no bond in these cases.
This is the turning point of the entire hearing. The prosecution has just tied together the defendant's probation history, the new felony allegations, the pending misdemeanor charges, and the reported probation violations into one overall argument that the defendant represents an ongoing danger to the community. Rather than focusing on just one accusation, the prosecutor is asking the judge to look at the complete pattern of conduct. Now the judge has to balance 2 competing legal principles. On one side is the defendant's request for bond. On the other is the court's responsibility to protect the public while ensuring future court appearances. Listen carefully to the judge's explanation, because judges often explain not only what decision they're making but also exactly why they're making it. Those reasons can reveal which facts carry the greatest weight. Do you think the prosecution has presented enough to justify a very restrictive bond, or would you have reached a different conclusion if you were sitting on the bench?
So obviously I agree with Mr. Smith. I think that you are a danger to our society. I am going to set bonds. I'm going to set bonds in each of your cases at $300,000. Conditions of those bonds, if you make them, are that you are on house arrest with a GPS monitoring device, and then we'll set your case for the appropriate hearing. Right.
This hearing ended with a clear message from the court. After reviewing the defendant's probation status, the newly filed felony allegations, the alleged probation violations, the financial testimony, and the arguments from both attorneys, the judge concluded that bond would not be denied outright, but it would be set at an exceptionally high level. The court ordered $300,000 bond on each case, along with strict release conditions, including house arrest, GPS monitoring, and electronic monitoring if the bonds are posted. It's important to remember that these are allegations, and the defendant remains entitled to the full legal process before any determination of guilt is made. Today's hearing focused solely on bond and community safety, not on deciding the ultimate outcome of the criminal charges. Cases like this highlight the difficult balance courts face every day, protecting public safety while preserving the legal rights of the accused. If you found this courtroom hearing interesting, what do you think of the judge's decision? Was the bond amount appropriate, too high, or not high enough? If you found this case as fascinating as we did, be sure to like this video, share your opinion in the comments, and subscribe to the channel for more in-depth courtroom breakdowns, legal analysis, and real case commentary.